May I seek a Lordship indulgence in mentioning one unlisted item for tomorrow, Lordship?
Just a minute. Pardon?
One unlisted item which I have filed yesterday for tomorrow, if the matter can be taken up.
Criminal? Criminal?
No, Lordship, it's a civil case, it's an application.
Okay.
Deeply obliged.
Motion item 1.
Your Lordship, even as earlier, Lordship, I asked for time for filing additional affidavit, Lordship.
Okay.
I think we may proceed on without that affidavit as of now, and if Lordship permits me, even after issuing notice, Lordship, I may also file additional affidavit, I think.
Okay.
So, for now, my Lord, we may go on and issue notice. This is a revision petition, Lordship, for quashing the order, my Lord, dated 27 October 2023, passed by the honest senior civil judge, my Lord, wherein the senior civil judge had state the proceeding undertaken by the petitioner bank, Lordship, for...
We have to see the applicability of Section 34.
My
right?
Lord, exactly that is.
Section 34. So,
Section 34 is specifically barred the jurisdiction of civil court. That is when.
there is a bar, but usually what happens is that in many
When there is
cases,
fraud.
plea of fraud is taken.
My Lord.
But the
That
plea of fraud,
That is-
you have to analyze the plea of
Your
fraud.
Lordship knows very well.
No, little bit.
There
not
is a
much.
limited scope for fraud. Anyway, let's see.
So
that.
we'll look for some
My Lord.
leading cases of Supreme Court on this
My
point.
Lord.
Okay.
Yes.
So at this stage, what should we do? Should I
Issue
fix it
notice.
or-
Issue notice.
yeah, I can issue notice, but in the meantime, you file your additional affidavit also.
That, anyway, let's issue notice anyway, Your Lord. If the need arise, my Lord, I'll pray for this court permission, Lordship. Thereafter, my Lord.
Okay. At the moment, I issue notice,
Just
and
that.
you have an interim prayer. Can it be considered after you file the additional affidavit?
That, my Lord, is interest as of now, my Lord. My Lord.
That can. That's why, if
My
you
Lord.
want, we can fix it a
My
short
Lord,
date,
my Lord.
and then we can consider. Okay. But this is a very interesting subject actually. Many cases come, surfacey versus the civil court jurisdiction, you know. So, the aspect of determining of the fraud is apparently, it's not so simple, you know. You have to look inside.
It applies only when English mortgage is involved.
It's a
my
genuine fraud.
Lord. Yes, English mortgage is involved. If that doesn't happen, it doesn't simply necessarily be allowed. When
The heard learned counsel, Mr. So and so. The instant civil revision has arisen out of a petition filed under Article 227 of the Constitution of India, read with Section 115 CPC, by the petitioner bank, agreed by the order dated you write, passed by the learned civil judge, senior division 1, Aizawl district, in CMA number 846 of 2023, whereby the prayer of the plaintiff in civil suit number 148 of 2023 for temporary injunction was allowed. They submitted that the primary contention is that a notice under section 13, I think, of the Surfacey Act, SARFAESI, Surfacey Act has been issued, and in view of section 34 of the Surfacey Act, the jurisdiction of the civil court is barred, and hence granting of temporary injunction is erroneous in law and facts. Full stop. The petitioner was supposed to file an additional affidavit, but the learned counsel submits that in the meantime the court may consider issuing the notice, and that the petitioner shall file the additional affidavit during this time. Issue notice upon all the 5 respondents impleaded in this petition. Full stop. steps may be taken expeditiously.
As of now, my lord, now
Your
GA
Lordship,
is
I will represent the respondent above 5 and 6.
Oh, I see.
So I
Four
will
and five.
accept
Oh,
notice.
Achha,
4 and
I
5.
did not see 4 and 5. Madam Learned Counsel so accepts notice on behalf of respondent number 4 and 5. Extra copies shall be furnished to the Learned Counsel. Then steps of notice upon 1, 2 and 3. Okay? 1, 2 and 3. But you will take it by speed post?
my lord.
Now it is speed post and
Yes, yes, yes.
registered is same. The petitioner is at liberty to file the additional affidavit. When should we fix it? When should
After 3 weeks, lord.
after 3 weeks?
My lord.
This is the matter after 3 weeks.
Obliged. Then
Item
the
2.
next item,
This is also same.
similar, my lord. But the respondent is
Is
a
different.
little different.
The-
Now, the government is only respondent
Order
number 5.
dated, order date will also be different.
Yes, order date is also different. And the case number of lower court, my lord, is also
That will
different.
be different, yes. You have not mentioned in the cause title the order, so we'll have to look inside. Order dated ... passed by same, civil justice so and so. Number 3. Number 3, Aizawl district. This civil judge is different. Different civil judge.
Different.
Oh, yes. CMA 570 of 2024. Okay. Civil suit is 77. I think you can represent only 5 here, right?
Only 5 years.
Madam will represent 5 extra copies, same. Steps of notice upon 1, 2, 4. 1, 2, 3 and 4. Okay. List after 3 weeks. And a date to be fixed by the registrar.
Admission, item 3.
Obliged, lord.
Yesterday's matter.
Yes, Your Lordship, I was instructed to obtain instructions in the matter yesterday with regards to the interim orders. Your Lordship, there is a case pending which is registered as WPC 83 of 2025. And in that case, pleadings are completed. It is the same exact matter. Now, in that case also, there are qualified, unqualified teachers. To meet the exigencies of the time, the government have decided to engage the unqualified teachers, but then their continuous engagement from year to year basis does not means that they are not
They will be entitled to regularization.
Yes, yes. And Your Lordship, since I was given a little bit, little time only, then
Yes, yes.
I will just...
I understand that.
Yes, produced, with Your Lordship permission, I can produce the affidavit that is filed.
In that case.
In that case.
What is the number, madam?
83 of 2025.
583.
83 of 2025.
83.
Yes. Now, what I would like to point out is
83
that...
of 2023.
Yes.
Okay.
WPC 83 of
That
2025.
pleadings are complete in that
Your
case.
Lordship, it's 83 of 2025. I'm sorry.
Sorry.
Pleadings are complete in that case. Now, there are numbers of unqualified teachers that are engaged by the
Larger issue,
government.
that means.
Yes. And then due to, we have given them new numbers of time to have the required qualification and giving them chances from year to year. Now they have been in this, they have been engaged for more than a decade. They were given a chance more than a decade to have the qualified degree, but till now they do not have. Now during the pendency of the that case, 83 of 2025, 2 persons have qualified, and they will be
Made contractual or something.
yes, they will be upgraded to
So,
contractual.
I think, did you say that the government in that case has decided to continue the unqualified for some time?
Not for some time.
Not
the
really.
unqualified will be terminated.
Terminated.
Will be terminated because they were given ample of chances. I can show it to your lordship that we have given in the engagement order itself also. We have reflected that.
Ma'am, which is this, the first one, the writ petition 16 of 26. As I understand, the Learned Senior Counsel was submitting yesterday
Yes.
that in the engineering, that technical stream, their stand is that qualification, which is essential qualification, held to be, that is not necessary. They are qualified. But in the others, they accept that the qualification of PhD or NET is necessary.
Yes.
But they are being given time also, and they say they in that case
So
they are
they have
seeking some time,
approached this, yes.
some more time.
Yes.
But in this case, they are contending that the qualification, the PhD is not necessary.
Yes, in
MTech
engineer,
is enough. That's
in,
what they say.
in engineer, they are guided by a different guidelines. However, the guidelines, as per the guidelines, they have to have, they have to pass in first class in all the class 12, class BE, ME, etc. So that required qualification is there. No, they cannot circle back and say that supposing if they have passed in first class in ME, but if they do not possess the first class in so and so as required, then they are not eligible.
Yes. Anyway, this matter is at what stage is it reached hearing? This matter, the other one, 83 of 25.
83 of.
It's,
Yes.
it has reached the stage of hearing.
Yes, yes.
Your Lordship,
It is
may
fixed
I
on-
just intervene?
Yes. I'll hear
In
you.
that 83 of 2025, the application, in that writ petition, they have sought for extension of time only till 28/2/2026. The difference here in our case is that since that time is going to an end, we have sought for further extension.
Correct, Your Lordship.
This is
now,
the
this
only
is only the
difference.
dialectory tactics that they are playing because they have given the chance and they were informed beforehand. And those petitioners have approached this honorable court for extension of time, in fact. But now at this, in the wee hours, they have approached this honorable court to make the interim order, to have the interim order for their extension. Now this is just one dialectory tactic that they are applying. They could have come and approached this honorable court before because they were given the chance since a decade ago.
Your Lordship,
And Your Lordship, if I may take Your
impugned-
Lordship
the
kind attention
impugned
to page
letter
70
is
of the
9
writ petition,
February
the instant writ
2026.
petition.
We have impugned the letter dated 9 February 2026, by which the discontinuance of engagement has been communicated to the principal for further information to the petitioners. So when we get the information that our engagement is likely to be discontinued and not to be extended beyond 28/2/2026, we have approached this honorable court. We're not taking, any dilatory tactic or any such as alleged.
Anyway, so you want, which page you want?
Your
me to
Lordship,
go?
they are the
Page?
the page 69.
Repetition.
Page 69 of the
AICTC.
petition. Yes. Now, the Department of Engineering will be governed by this AICTE. And if I may take Your Lordship kind attention to page number 70.
70.
70. The qualification required for assistant professor.
For teaching MCA.
Yes.
That's what they said
Yes.
yesterday, that for MCA also,
Yes.
PhD is not seen as one of the prescribed
Yes, Your
qualifications
Lordship.
in this table, right?
Correct, correct. Now, Your Lordship, what I'm trying to point out is that BE, BTech and MCA with first class or equivalent in either BE, BTech or MCA with first class. So first class is required. Now, where is the mark sheets that is attached here in the annexed here in the
First class.
in the writ petition, so as to see that they are fully qualified as per the AICTE rules. Now they do not enclose that. If they did so, then the interim order they prayed for, I could have understand. Now that is why I'm saying that in the wee hours they have approached this honorable court with the main document, the core issue, that is the first class degree that they should possess and attached here or enclosed here with. But To get the interim order only, they have approached this honorable court at this time, at this belated stage. Now, this is the equivalent.
Of course, we can always issue notice, but the challenge at this stage is the interim prayer.
Yes,
Because
only,
the
I'm answering.
Term
only
is
the
coming to an
interim,
end,
yes.
you know. But you're right, in a sense, that this is appears to be one of the essential qualifications.
Yes, this is the
If
essential
not the
qualification.
PhD, the first class degree,
Yes.
right? So, does these two writ petitions need tagging with this case, 83 of 25?
In those two
If the issue is
cases,
same.
net is the qualified, minimum qualification.
In 83.
Yes, 83.
So this need not be tagged with that.
No,
It may not be tagged.
it may not be tagged because their prayer is a little bit different.
Different. No issues.
Even though the issues are more or less the same.
Your Lordship,
If you have the first class, you can file it.
Yes,
Even now,
yes, we have
through an
all the
additional
first class.
affidavit, and we'll fix it.
It's
We'll fix it
an
on
omission
Monday.
on the
No
part of-
interim, Your Lordship.
And we can fix it on Monday for hearing on the interim prayer.
Yes.
If they file the affidavit.
Yes, Your
And in the
Lordship.
meantime, we can issue notice. That is one plan.
All right, all right.
Can it be?
Yes.
Monday may be difficult, Your Lordship. Let it be taken up on Wednesday.
Yes, I have no problem. Wednesday, I think, is a holiday here.
Wednesday.
4th is holiday, I think.
Oh, yeah.
4th.
3rd is open. 4th is a holiday.
5th, Your Lordship. We'll file our affidavit in the meantime.
I'll be leaving on 5th, but because I have a training in Bhopal.
In
I'll
that
be going
case,
from
Your
Delhi.
Lordship.
I'll be going from Guwahati on 6th.
We'll do it on
Justice
3rd.
Kolita.
3rd, Your
So,
Lordship.
but Thursday I'll be available. If we fix it as the item number 1, we can hear it because I'll be attending court. Because, if it lingers, then it will be a problem. But because otherwise, I can take up. 3rd will be very safe from that point of view. But I think senior counsel sir has
Yes.
problem.
3rd, we can make an attempt on 3rd, Your Lordship.
Fix it on 3rd.
3rd.
Yeah, that will be better. The previous order, para 1, 2, 3, you can take it out. Okay. Issue notice, 3 respondents. You will be representing all of them.
Yes. So, Your Lordship, I'll be representing the, yes, all of them.
Learned counsel, madam. So, this undertakes to represent all the 3 respondents, and notice be issued upon the said respondents. Extra copies be furnished to the learned counsel representing the respondents. Additional AG, additional
No, Your Lordship,
additional
government advocates.
Government advocates. Extra copies be furnished. Full stop. Should I record a bit of your submissions also at this stage, or not necessary?
Not necessary because we're going to have hearing on that particular term.
If you want to file a quick counter, you can.
Yes, I will.
On the next date fixed, the prayer for interim would be heard. In the meantime, the respondents are at liberty to file their written pleading, if any, including on the point of interim protection. The petitioner side is also at liberty to file any additional pleading
All right.
if you want to bring that qualification.
All right. We'll
on
place.
that. Because whatever helps in the decision for the court is welcome, right? So we fix it on 3rd for the moment.
Yes.
This
No,
will be
please.
the almost the same order in the next one also.
Your Lordship,
Next
there's a
one
difference.
issue is slightly different
There's a difference in the
because
second
they are
case.
seeking time. They are seeking time.
They are seeking time on
There is
humanitarian
no,
grounds.
there is no dispute with regard to the qualification. The last extension was also given on humanitarian considerations.
Yes, yes.
I don't know what would be the, it's not for me to say at this stage for the court, what would be, the right, how much extension can be given. That if we are required
At
to
least, Your Lordship,
decide
during-
that in judicial review is another matter, but for the moment is the authorities have to take a call on that. So
if extension is given during the pendency of the writ petition, Your Lordship, we have no link with the first writ petition, which is 83 of 2025. The difference here in our present case is that we have pursued our respective research, and one of us is about to submit his thesis.
Bless you, sir.
And some of them are still proceeding with the research. And with the burden of having regular classes in the college and not being given the leave required for pursuing their course, it is very difficult for them to complete.
NET and PhD are alternative qualifications, right?
Yes.
If you have NET, you need not have PhD. And if you
But
have
since
vice
they are
versa.
now pursuing PhD, they have concentrated on that research. NET is a vast matter, so it's a broad-based, preparation is required. In PhD, that is different. So since we have taken up a PhD course and the research, we are concentrating with all difficulties. And now, as stated earlier yesterday, Your Lordship, we have given all efforts as stated here
Next one.
in para 12.
So what would be your take, madam, on this? On
Your
this
Lordship,
matter?
admittedly, they are not qualified. And admittedly,
We
they
have
are given
admitted
number
that.
of
We have
chance.
admitted that.
That's okay, fair enough.
And what we have stated here is that we have pursuing our PhD research with all devotion in spite of all difficulties. And now, some of us have reached the stage where it is possible to submit the thesis. And in the middle of that, if the engagement is cut off, it will be cruel on the part of the employer also. What we have stated here under para 14, in para 12, we have stated all that we have done in connection with the research. In para 14, we have made a submission to the effect that, Your Lordship, so far as our continuation or engagement as part-time assistant professor, it cannot be said that we are not qualified. But since most of our friends who had obtained the required degree, that is PhD or NET, for the purpose of appointment on contract basis, since they have been given appointment on contract basis on acquisition of their required degree, and since we have been left behind, now we have tried our level best. The interview board, the departmental selection committee, they had interviewed us and they have checked everything that was required. And what I have said is that the petitioners were found to be qualified and eligible for engagement as part-time lecturers or assistant professor in the government colleges way back in the year 2011 on the basis of advertisement dated 3/10/2011. And the departmental selection committee, after conducting necessary personal interview and screening of all academic records produced by them at the time of personal interview, had recommended them for engagement as part-time lecturer to said post. Now, after serving in the same capacity for more than 10 years, and after acquiring lots of experience and after pursuing the research for obtaining
That is
PhD
fair.
degree under different universities, it is quite unconscionable to grade them as unqualified for the purpose of engagement as part-time professor. And also, my humble submission is that we are qualified for engagement as part-time assistant professor, but not qualified for the purpose of appointment as contract assistant professors. So contract is a different status. For the purpose of contract appointment, one has to have all the requisite qualification, and there has to be a vacancy also. And now, after having all those qualifications, we may be upgraded to contract appointment, subject to our qualification. Now, and subject to availability of the vacant post.
We definitely we issued the notice at this stage,
Lordship.
you know, and again, should we fix on the same
Same
day?
date,
Same
same
day.
Yes,
Same
Your
date,
Lordship.
but in the meantime, Your Lordship, since there is a gap, there's
the
no
earlier-
problem.
I will
That's
inform.
the
I will
very
inform.
reason
It's just
why-
a matter of one day. I will inform.
That is the very reason why Your Lordship had fixed today for further hearing
Because
of the
that's
interim.
she has a point that it's it's just at the wee hours, just fag end. Anyway, so even if we fix it on 3rd, it will be beyond that period.
Yes.
Actually, tomorrow is the today is the last. Tomorrow is the last actually. So anyway, and since they have to be re-engaged, the term itself is coming to an end, and they have to be re-engaged. So allowing them to continue by an interim order has its own challenges. So anyway, issue notice. Madam Learned Addition, Government Advocate accepts notice on behalf of all the 3 respondents. Extra copies be furnished to the Learned Council. The respondents are at liberty to file their counter affidavit, if any, including on the point of interim prayer made by the petitioner side. The petitioner side may also is also at liberty to file any additional pleading, to bring any additional facts if so desired.
All right.
You have narrated, but one piece of I think it will be available in this the pleadings itself, that when did they join in the PhD, and how long approximately it might, some more time it might take.
It's,
That can give an idea.
yes, Lordship.
And if you want, you can file. Otherwise, you fix it on 3rd. We'll hear it on 3rd.
All right.
Item 5.
3-3. It's your matter also.
Lordship, in this, we have received additional affidavit filed by respondents number 5, 6, and 7. And we may like to file a reply affidavit to that.
There are 2 lands, 2 villages covered. One village basically we have done nothing out there. Oh, is it? I'll ask my. This will make it clear. This you can click. This is what is next.
The pleadings are almost complete. Yeah.
Almost complete, my lord.
Complete from the respondent's side. Would like to file a reply to the additional affidavit. It'll take a short time, Your Lordship.
You are representing
Well, I'm for 5, 6, and 7.
5, 6, and 7. The engineering projects India Limited. Your good name, please.
D. Gogoi, my lord.
D. Gogoi, Learned Counsel, appears on behalf of respondent number 5, 6, and 7. Madam, you are for the
I'm for respondent number 4.
for the union. Respondent number 4. And 1, 2, 3. 1, 2, 3. That's true. Affidavits. All of you have filed affidavits.
Yes, yes.
Whatever.
Affidavit on behalf of the aforesaid respondents have already been filed. Full stop. The Senior Counsel submits that he would like to file a reply to all the affidavits.
We have
some
filed
of
in
them.
some. We have to file in respect of the additional affidavit recently filed.
Okay,
By
additional
5, 6 and
affidavit
7.
file, who has filed additional
I
affidavit?
had filed, my lords.
Okay, you have filed affidavit in opposition as well as additional affidavit.
Yes, my lords.
The respondent number 5, 6 and 7 have also filed an additional affidavit. The learned senior counsel, then you bring it.
I'll show you.
Learned
here.
senior counsel submits that the petitioners would like to file a reply to some of the additional, to some of the affidavits filed by the respondents. Prayer is allowed. This is the matter on.
I have given this to one of my friends, Silo, Lansing Silo.
Do you have any preferred date?
Preferred, let it be one Friday, my lords, because let it be a Friday.
Friday.
Let it be
27?
27.
27 March.
Tomorrow.
27 March.
27.
Tomorrow is 27 March. 27/3. It's a Friday. 27/3. In the admission column. It will remain in admission column only.
My lords.
Item 6.
Rather than sleeping actually. Keep it on the side. Keep it
My
on the
lord,
side.
although this is a fixed matter,
Sleeps otherwise.
my lord, although this is a fixed matter, the counsel for respondent 6 is out of session. So if this matter may be fixed on another day.
You are for 6.
My lord,
My lord.
let me raise one point, my lord. This case, there is some urgency, my lord. My lord, this case, there is some urgency in that, my lord, the issue involved in this case is with respect to the post of the registrar in the Mizoram University, my lord.
I see.
And the case has been lingering for more than 1 year now, my lord. So my humble prayer at this stage is, my lord, if this matter can come up again as a fixed item on 5th, my lord, 5th March.
5th March.
Yes.
Heard the learned counsel for the writ petitioner. How many respondents are there?
My lord, there are 5 respondents.
5 respondents are there.
So, my lord, there are 6 respondents.
6 respondents.
And adjournment is made by the respondent number 6, my lord.
6.
Yes.
Writ petition. Six respondents have been implemented, full stop. Affidavit in opposition has been filed on behalf of, how many respondents?
6
Not all of them have filed.
All of them, on behalf of all the respondents. Madam, you are representing,
1 to 5. Respondent 1 to 5.
okay, so representing 1 to 5. All have filed the affidavit. Learned counsel appearing on behalf of the respondent number 6. Another date for the matter as the leading counsel is stated to be out of station. Full stop. However, learned counsel for the petitioner submits that there is some urgency in the matter and the matter has been pending for some time. And he prays for an expeditious adjudication. Full stop. You filed any reply or something?
My lord, we have, the pleadings are complete, my lord.
Pleadings are complete. It is submitted by the learned counsel for the petitioner that the pleadings are complete. So you work out a date, 5th, because the other 2 matters also we have fixed just now on 5th. And I'll be leaving on 5th actually, because on next day I have to go to Bhopal. So, because there may be some time constraint.
My lord, then on 9th?
Yeah, it can be. 9th will be good. Can be.
9th of March, my lord.
9th of March.
Yes, yes.
So it can be heard and
Yes, it can be disposed of, my
should
lord.
it remain in the admission column?
Admission stage.
This is the matter on 9/3/2026.
Deeply obliged, my lord.
Item 7 and 8.
May I please, Your Lordship? Lordship, as per the last court order dated 21/1/2026, I have taken service upon the respondents number 2 by way of newspaper publication and speed post. And that affidavit, I have filed my affidavit yesterday.
Who is respondent number 2? The driver?
Respondent, no, Lordship, the owner of the
Owner of the
vehicle.
vehicle. Yes. This is a Mizo newspaper, right? I saw post.
And Newslink, Lordship, that's the Newslink.
Yes. What is the tracking? It has been with regard to another one.
The item delivered on 20/2/2026.
It's okay, no
In Hinsdale, SI.
Heard, so learned for the appellant insurance company. Let's do. Here is the order dated 21/1/2026. Let's do. It has not yet been admitted, I guess.
Yes, not with,
Not yet admitted. And there are two respondents, right? You are appearing for one?
I'm for respondent number 1.
Madam Learned Counsel appears for respondent number 1. You have received the copies, necessary copies of the appeal memo and all that?
Yes, my lord.
And submits that necessary copies have been received. With regard to respondent number 2, the appellant has taken steps of substituted service by way of newspaper publication in terms of the order dated 21/1/2026. You have submitted an affidavit also.
yes,
right?
Lordship.
Compliance affidavit along with the newspaper, relevant newspaper copies in original have been filed, and I have perused the same. In terms of such substituted service, service upon respondent number 2 stated to be the owner of the vehicle
Yes,
is deemed to be complete, right? Full stop. If they can, if there's the appeal stands is admitted for hearing. Call for the original TCR of MACT case number 38 of 2020 from the court of the learned member MACT Aizawl district. What else? You want paperwork will be necessary? No?
Not necessary,
Not
Lordship.
necessary. List after 4 weeks in the orders column, right?
Yes, Lordship.
And after the TCR comes, it can be heard.
Deeply obliged.
Cross objection. Your file?
Yes, my lord.
You're the insurance company.
No, I'm for the claimant.
Driver.
The claimant.
Sorry, insurance is the appellant. This cross objection has been filed in MAC appeal number 12 of 2025, which has been admitted by its separate order passed today. Full stop. The The cross objector herein is the respondent number 1.
One.
No, respondent number 1
One.
of the MAC appeal, number 12 of 2025. Full stop. Service will do. Service will be same, I think.
Yes, sir.
Yes, my lord.
The insurance company is represented by learned counsel. So full stop. In the MAC appeal number 12 of 2025, so newspaper publication was with regard to the cross objection as well. It was with regard to the thing also.
Not be, Lordship, I think it will not be required in the cross objection.
It will not be required.
Yes, sir.
In the MAC appeal, I'll just make a mention about this. MAC appeal 12 of 2025. Substituted service was resorted to by way of newspaper publication upon the respondent number 2 therein stated to be the owner of the vehicle, and upon perusing the compliance affidavit and the newspaper publication, this court by separate order passed today in the said MAC appeal give a dash has held the service to be complete upon the said respondent / owner. The original TCR has already been called for in the appeal of MACT case number 38 of 2020. This is the matter in the orders column after 4 weeks. And tagged with MAC 12 of 2025.
Deeply obliged.
Obliged.
Item 9.
Just a minute. Yes, sir.
Manoj, I'm appearing for the respondent in this case. We are yet to file our objection, Manoj. This case has come back for mediation, Manoj.
Just a minute, let me have a look. Scrivener provision is filed within PM of the post by Airship certificate. I see. You filed a affidavit.
No, I haven't filed.
Okay.
I seek time, Manoj.
There is a mention. Oh, okay. Oh, it's not yet filed.
Yes.
Regarding airship certificate.
Regarding
Airship certificate is similar to succession certificate.
Yes, Manoj.
Similar to that.
Yes. Normally here succession certificate is given in respect of bank account. Airship is given in respect of land and building.
Yes, yes. Oh, yeah, the immovable property.
Yes.
Yes,
yes.
Succession certificate is for only movable property.
Yeah,
actually. Even that is not necessary if you have a nominee.
Yes, Manoj. That's correct.
It can save people a lot of trouble if they have a nominee. Learned counsel, since I appears for the sole respondent, right?
Sole respondent.
Full stop. Learned counsel for the sole respondent submits that he wishes to file an affidavit in opposition, which has not yet been done so, and seeks some time for this. When should we fix it? After?
After 2 weeks.
List the matter after 2 weeks on a date to be fixed by registry.
Yes, Manoj.
Can we have a date, Lordship?
You want a date? You can
Yes,
suggest
a
it.
fixed date, my lord,
Huh?
if possible. If we can have a fixed date, Lordship.
I can. We can. You can suggest to me.
Today is
After 2 weeks.
12th of March.
12/3.
Obliged.
Obliged.
Item 10.
Lordship. Lordship.
It's a writ petition criminal, right? So
Yes.
It's pertaining to a bank. That's what I was wondering. Just, what is it come up for?
Your Worship, in the last court date, the case report was called for from the learned trial court, and the registry have duly received the case record, and I have flagged the important portions because it was called because one of the grounds is that they were not informed of their grounds of arrest,
Okay.
etc.
So what is the, just give me 2 minutes. I'll just have a look at the last order.
Sorry. Your Worship, I'm totally, my sincere apologies, different case.
It's a different case. Never mind. There's some freezing. I'll just have a look at. There is a stay order.
Yes. In the last occasion order, Your Lordship.
It's a order of magistrate in Chennai.
Yes, my lord.
Chennai.
Yes.
Then what about the jurisdiction?
My lord, that,
Kolasib branch.
yes.
Who's appearing for the other side?
My lord, notice was complete and add from my side, and at the return was from respondent number 1 and 2 have returned. But however, at the for the respondent number 3 to 5 is not have not been returned.
Not been returned. It's a quashing petition. Essentially, it's a quashing petition, actually. So public prosecutors' presence would have helped, but cannot appear because so it's been registered as a writ petition.
Yes.
So the government advocate has to appear.
Your Lordship, may this matter may kindly be listed after 4 weeks for to await for completion of service.
Just a minute. I'll do that. One and 2, it has come back,
Yes.
but the others, it has not come back.
Yes.
We will have to wait for some time.
Okay. My lord, in the meantime, I pray for a further interim order.
The interim is already there, but
Yes.
till today. Heard land counsel appearing for the writ petitioner. We'll stop. Service report has returned as per office note dated 25/2/2026. AD card regarding service of notice has returned back from respondent number 1 and 2. 5 respondents have been implemented. Service steps, it is submitted that from the office note dated 16/1/26, it appears that steps of notice has been taken upon all the respondents. However, service report, it is submitted by the learned counsel that service report is awaited from respondent number 3, 4, and 5. Wait, where is the office, this AD card? I'd like to have a look. It's in another file. I'll just have, this will be the order. When should we fix it? After?
After 4 weeks.
After 4 weeks. Date or registry? The interim order granted by order dated 13/1/2026 shall continue till the next date of listing. This is the matter after, let us fix a date, it will be better. Huh? This is the matter after 4 weeks on. You can suggest as per your convenience.
4 weeks.
Today
Any
is-
days, my lord.
Yes, I'll just 26, 4 weeks would be something like 24 March, huh? 24/3.
Item 11.
Mr. Rohan.
My Lordship, there is
Insurance appeal?
Insurance, yes, no return from both the respondents till date.
Not yet returned.
Not yet returned. The office not.
Heard Mr. Rohan. For the appellant insurance company, it is submitted that those steps of notice have been taken on both the respondents, but service report is awaited. Full stop. The same is also reflected in the office note dated 25/2/2026. Full stop. Await service report. Full stop. This is the matter after 3 weeks. 3 weeks. 3 weeks on a date to be fixed by the registrar.
Orders, item 12.
Your Lordship, this is a bail application.
He is in
section-
custody since 27/9/2024.
Yes, my lord.
Commercial quantity, right?
Yes.
Anyway, so yes. Yes, go ahead, please.
Yes.
With your
Your,
submissions.
Your Lordship, the petitioner was arrested on 27/9/2024. And for the alleged acquisition of 35 kg of suspected methamphetamine recovered from the authorities. So I want to submit that the petitioners have not involved in this case because the alleged articles were not seized from the physical possession of the petitioners, my lord. And my grounds on page 7. Page 7. My lord, there is a violation of Article 22(1). As there is no grounds of arrest in writing, were not communicated.
Okay, page?
Page 7, my lord.
Oh, sorry, that's your narration.
We are not communicated to the petitioner, my lord.
At that time, I think it was 50, section 50, CRP.
Yes, my lord.
47 BNS.
Yes, my lord.
BNSS.
Yes.
No grounds of arrest furnished.
So-
second ground.
The grounds of arrest were not communicated in writing, so my lord, I want to submit this honorable court already consider the same grounds of arrest is not provided to the petitioner. So I want to submit this one. So, Your Lordship, I pray that the same parity as the Honorable Court already considered the similar case, the similar grounds. So, my second point is there is a violation of Section 105 of BNSS, my Lord. As there is no videography of seizure, search, and arrest, my Lord. So, there is there is a violation of 105 of BNSS. That is my second point, my Lord. And my third point is
What is the stage of this case? It is investigation is over.
yes, already over.
Trial is going on.
Yes, my Lord.
I see. First, we have to negotiate this grounds, which have the grounds of arrest. If thereafter, we have to see 37. If these are not upheld, if it is upheld in your favor, then you will be entitled to grant bail. Then we need not go into the merits also of the bail petition. This is in a different case, right? Different case.
Yes, my
Similar.
Lord, different case.
That's all. These are the grounds.
No, my Lord.
You can always come reply. But,
Yes.
You can you complete it.
Yes, my Lord. And my third point is there is a procedural lapse in arrest. May I take your Lordship through page 32? Our information report was received by Mr. Biek Chung Nunga, and my Lord, authorization was given. And after page 33, authorization was given to S.I. Lalpiang Sanga, to Mr. S.I. Lalpiang Sanga, Your Lordship.
Page 33.
Yes, page 33. Authorization of search under Section 41(2) of NDPS Act was issued in this case.
To the SI.
Yes.
SIs are authorized persons.
But, my Lord, the petitioner was arrested by S.I. Biek Chung Nunga. There is a different person.
Different person.
Yes, my Lord. And also, my Lord, in page 34, grounds of belief. The grounds of belief was not received by the OC within 72 hours. And also, the petitioner signature was not there.
The grounds of belief will not, because that is. Anyway, so.
Also,
Where is the grounds of arrest? You said it is inadequate.
grounds of belief in page 34, Your Lordship.
Page 34.
Yes.
Grounds of arrest.
Grounds
No,
of
no,
belief.
not grounds of belief. The grounds of arrest.
No, there
notice.
is no grounds of arrest.
Notice was not given.
Yes, my Lord, in this particular case.
So no. Okay, we'll cross check that. Okay, then.
So I want to submit this Supreme Court judgment, if I'm allowed to.
Yeah.
Lordship, in last Para, in conclusion, the grounds of arrest must be communicated in writing. Yes. So, in this case, there is no grounds of arrest in writing.
At all?
Yes, my lord.
Arrest, what was the date of arrest?
27.
20, yes,
27,
9.
9, 2024.
By the time
Yes,
BNS
Your Lordship.
had come
Yes,
into
yes, Your Lordship. And I want to submit this one, if I'm allowed to.
Yes, sure. Mir Rajeshah is a recent judgment, also summarized. Forecast years.
Yes. Lordship, in that case, in para 20, resultantly, there is no doubt in the mind of the court that any person arrested for allegation of commission of offense under the provisions of so and so has a fundamental and a statutory right to be informed about the grounds of arrest in writing. And a copy of such written grounds of arrest have to be furnished to the arrested person as a matter of course and without exception at the earliest. My lord, there is no grounds of arrest in writing in this particular case. So I pray the petitioner must be enlarged in bed on this ground.
Should I go to her?
Yes.
Prosecution?
Yes, Your Lordship, I have gone through the records that was sent.
What did we call for? Scan copy or
Scan copy
case
of
diary?
scan copy of the case record.
Okay.
So I have gone through, and unfortunately, there is no written ground of arrest,
Okay, that's okay.
admittedly. But then what I would like to state in that is that, yes, in writing, it is not there. But then he was, the accused were informed of their grounds of arrest orally, which can be seen from the case record. And in the note sheet also, in the first page of the note sheet, which I have already flagged, it was written clearly by the remanding judicial officer that they were informed of their grounds of arrest and then rights to consult a lawyer, etc., etc. So they were made known. But in writing, it is not there.
It's not there. On merits, there are materials?
On merits, trial is going on.
Because 37, as you know, is a very difficult
Yes,
test.
yes.
It's a very difficult
Twin
test. It is
conditions
more
are-
difficult than the test of 43D5 of UAP Act. Because there you have to say that, the court has to hold before to grant bail for some sections, not all. That the prima facie materials are there. But here, in NDPS 37, the court has to say that there are reasonable grounds to believe that he is not guilty. This is a higher
Yes.
test. And after filing of charge sheet and framing of charge, it is very difficult to say, or somewhat contradictory to say, that he is not guilty. Otherwise,
Yes.
if there are no prima facie materials, charge would not be framed. But if he is found to be entitled to be granted bail on grounds of arrest, then he is lucky. Otherwise, 37 is very difficult. Fair enough. No written grounds of arrest. But I have to also refresh myself. Has the Vihan Kumar and all said that written grounds of arrest
Yes,
is to be
it is there, yes, Your
specifically?
Lordship. And
Yes.
the latest one is Mihir Rajesh. I think my learned friend will be able to produce. In Mihir Rajesh, I don't know, in SEC citation, but then in the original...
Yeah, it's quite clear.
It's written in paragraph number 10 that if it can be orally done so, but then writing should be provided before at least 2 hours prior to remand.
True.
Yes. So it is there.
Quorum is same. Same. This is also has the same quorum. No, in Mihir Rajeshah is clearly written. Prukasto also it is clearly
Yes,
written, but it was in the context of PMLA. But subsequently, in Vihan Kumar, it has also been indicated. But in Mihir Rajeshah, it is very clearly stated. Grounds of arrest must be communicated In writing.
in writing to him and the family.
Communicated in writing and in a language that he understands.
Yes.
There, of course, it doesn't have to be, may not be essential to have it in each version of language, where the explanation can also do sometimes. But anyway, so if in that case he may be entitled. Can I have this record?
Records.
I'll dictate the conclusion part. I am reserving that. I'll give it today only. No. Manoj. No. Heard that counsel appearing for the petitioner, full stop, and learned additional people for the state of Mizoram, full stop. Invoking the provisions of section 483 BNSS.
Yes, my lord.
Have a seat. Have a seat. BNSS. The petitioner herein is seeking bail in connection with Vaidangte PS case number 44 of 2024 under section 22C/25-29 of the NDPS Act. Full stop. The gist of the allegations in the FIR dated 27/9/2024 is about recovery of 35 kgs of suspected psychotropic substances in the nature of methamphetamine from the petitioner and the from the
May I, my lord?
from the co-accused.
Yes, my lord.
Let us go to the FIR once.
18. Yes, my lord. FIR on.
You have submitted at the outset that it is there was no recovery from him.
Yes.
He was He was arrested during investigation.
No, my lord.
At that time only.
Yes, at that time. And the
They
six
were-
article
they-
was the 6 articles of 18 kgs was recovered from the petitioner and the co-accused. The co-accused, Mr. Lalmangay Izwala. Mr. Lalmangay Izwala. And the co-accused is Mr. Lalmangay Izwala. And the seizing officer recovered 17 kgs of methamphetamine. Yes, suspected.
How did he come into the picture? The
Yes,
present?
my lord. The recovery was made from 2 autorexo, my lord.
Two
Yes,
locations.
Yes, true. 2 autorexo. One is from the petitioner's autorexo allegedly.
Okay.
But yes, my lord.
Then we can write
Yes, yes.
from the recovered from 2 vehicles within bracket auto rickshaws in which the petitioner and other co-accused were found. Full stop. Fine tune it. Full stop. The case was investigated, and after completion of investigation, charge sheet subsequently charge has been framed, charge sheeted by CS number 3 of 2025 under same sections. Subsequently, upon framing of charge, the case is at the stage of trial in criminal trial number 10 of 2025 before the learned special judge NDPS ISO.
No, my lord. Colossi.
And
First
at-
Track court.
at
Yes.
Kolasi.
Yes, my lord.
Yes, Kolasi. Full stop. The present petitioner was arrested on 27/9/2024 itself, and since then he is in under trial detention and presently in judicial custody. Full stop. The scanned case record was called for and received. Full stop. The learned counsel for the petitioner submits that the petitioner denies his involvement in the alleged offences. One of the main contentions of the petitioner is that no grounds of arrest were furnished to him at the time of arrest, thereby violating the constitutional provisions under Section 22/2021 of the Article 22 or 21, full stop. It is also submitted that there was no videography of the seizure and procedural infirmity as well in the arrest, in as much as the SI of police was authorized regarding the operation, did not commit the arrest, and that it was done by another police official. It is also submitted that the grounds of belief under Section 42, subsection 1 of the NDPS Act was not received by the OC of the concerned police station. Full stop. In support of his contentions, the learned counsel for the petitioner relies upon the following decisions: Mihir Rajesh Shah, so and so, Pravir Prakash. The learned additional PP fairly submits that upon perusing the case record, she has not noticed any written grounds of arrest being furnished to the petitioner at the time of his arrest. But however, it is submitted that there are materials to indicate that the grounds of arrest were orally conveyed.
By the police personnel as well as the remanding judicial officer.
By the police personnel as well as
The remanding judicial officer.
okay, that will by the police personnel. Full stop. I have perused the relevant materials and considered the. Have a look here. In view of Mihir Rajesh Shah, I think you don't have any chance, because otherwise it's clearly because as I said in Prakash, it has graduated like that, right?
Yes.
There was a Pankaj Bansal, then it was Pravir Prakash.
Pravir and
Pravir Prakash, clearly it was written that it has to be in writing, but it was more in the context of PML. Then Vihan Kumar again said that it has to be in writing, but it indicated an exception that sometimes there has to be, but there has to be materials to indicate that it was conveyed. But Mihir Rajesh very specifically says. Full stop. Before peruse and considered the submissions of the learned counsels addressed at the bar on both the sides. Full stop. The quantity of the contraband in question being in the bracket of commercial quantity, the applicability of Section 37 NDPS Act also has to be seen. Full stop. Admittedly, the written grounds of arrest were not furnished to the petitioner at the time of his arrest, as contended by the petitioner counsel and also as fairly submitted by the learned additional people. Before proceeding further, paragraph 56 of Mihir Rajesh Shah may be reproduced herein below. Thus, it is clear that grounds of arrest. Thus, it is clear from the reiteration in the aforesaid decision of Mihir Rajesh Shah, Supra, that grounds of arrest have to be communicated, done so in writing, and done so in a language that the arrestee understands. It further follows that any non-compliance would render the arrest fatally infirm, and the person would be liable to be enlarged on bail, as his continued detention would be untenable. The aforesaid principles also follow from Pravir Prakash Supra and the decision of the Honorable Supreme Court in Bihan Kumar, so and so, so and so. Full citation, full stop. It has been also held in Bihan Kumar that if an accused is found entitled to be granted bail on these grounds, statutory restrictions on grant of bail, such as Section 37 of the NDPS Act, would not also come in the way. In the instant case, in terms of the law laid down by the Honorable Supreme Court, I am of the considered opinion and finding that the petitioner has become entitled to be granted bail due to infirmity in the grounds of arrest and violation of the constitutional mandate under Article 22 of the Constitution of India. Full stop. In such a situation, the applicability of the rigors of Section 37 of the NDPS Act need not be adjudicated. Accordingly, in view of the above discussion, I allow this bail petition, and he is allowed to go on bail of rupees, how much? 75,000?
5,000, 50,000.
50,000. No,
Your
he's lucky.
Your
He's
Lordship-
quite lucky to get away. Lots. Pita man is very dangerous.
Your Lordship,
no?
yes, that is my
Lots
only...
of them. 35 cases. 50,000 with one surety of the like amount to the satisfaction of the concerned learned court, special judge, Kolasip. And subject to the following conditions, he shall not abscond, he shall cooperate with the remaining trial, not hamper or tamper with evidence, not commit any illegal activities, including any offences under the, he shall not commit any illegal activities or offences, including any offences under the NDPS. Violation of the bail condition would entail cancellation of the bail. Bail petition stands allowed and disposed of. Return. We did not return. This will remain. Okay. He has been there for a long time, no doubt.
Hearing item 9.
No, we have a hearing matter also. This is done already, so which was 9? This is part 2.
For delivery judgment, item 1.
Item 1, yes. This criminal petition is allowed, and accordingly the bail granted to the respondent number 2 is cancelled. A copy of this order shall be sent to the IO of the case along with the return of the case there.
Deeply obliged.
Delivery of order, item 2.
For the reasons indicated in the bail petition and in the circumstances and considering the materials, this subsequent bail petition also stands rejected at this stage. Okay?